No, there are various aspects to a criminal investigation. One of the things an experienced litigator will learn over time is that you can't take anything that the police say or the prosecutor says at 100% accurate. In my own investigative experience, I was an FBI agent for a number of years. I learned what I was taught in law school, which is that you have to really investigate and know all the facts before you can accurately assess a certain situation. Although we depend on police officers and prosecutors to be honest and forthright in all their dealings with defense attorneys and really with the public, many times that is not the case. That is my job. My job is to protect my client's interests. And to me, that means using all my skills, both my investigative skills and my legal skills, to determine whether or not a viable case exists against the client. And every defense attorney worth his salt knows this and should be doing this. For instance, if you're taken into custody by the police based upon a statement that some officer receives from a confidential source, one of the things I want to know is, well, how reliable was this confidential source? In other words, has this officer had good results before in dealing with this individual? Has the officer made sure that the individual informant has given reliable information in the past? Has information that the officer has received from this informant been proved reliable and so reliable that the officer has made other arrests and has obtained convictions against those arrested as a result of the confidential informant's information? Magistrates should ask these questions before issuing a warrant, but many times they don't. And this is a problem that all defense attorneys, especially criminal defense attorneys, face. Is you have an officer who has developed a professional relationship with a magistrate, and he goes in and he gives his affidavit or his statement under oath to the magistrate, and the magistrate doesn't ask any questions. That's what the lawyer is supposed to do. When you get to court at a preliminary hearing stage, for instance, in a felony case, that's the defense attorney's opportunity to first question the veracity and reliability of the sources of information that the officer obtained and upon which he relied upon to have, quote, probable cause to arrest the client. And many times it's possible that the officer missed something and the arrest can be quashed and the person set free. In my own particular experience, this has happened several times to the client's satisfaction. One particular instance occurred about 4 years ago when I had a client who was arrested after being identified as someone who was involved in an arson case, a very serious arson case. And the arrest was based primarily on the fact that the man's former girlfriend was mad at him. and she heard about this fire. She called the police the next day and said, you know, I think he was involved in it. He made these statements to me that the previous night, and when I saw him leave the house, he went to this garage next door, and a few minutes later I saw him carrying out a large can of gasoline and getting into a car with someone else, and they sped off. And when they interviewed the client, he didn't know anything about it. He didn't know what they were talking about. And when he finally figured out that he was a target of an arson investigation, he stopped the interview and said, I don't want to talk anymore until I've had a chance to talk to my attorney. At which time the investigators stopped the interview, as they should do, and they're required to do by law. But even though they had nothing to link him to the crime other than the statement of his former girlfriend, they arrested him. And he was held in jail for 4 days. I met with him the morning after he was arrested and got a full statement from him as to his whereabouts at the relevant times, and immediately began my own investigation. And I was able to verify that he was with third parties, that he was at a place or places during the relevant times of that the crime was supposedly committed. That he was not even close to the location. And I took this to the Commonwealth's attorney and said, I think this man is being set up and you people are being deceived. And the Commonwealth's attorney had the investigators re-interview and conduct a background investigation of some sort on the former girlfriend and her current boyfriend. They confronted her a couple of days later, and under extensive questioning by the same officer, she finally broke down and admitted that she had made the whole thing up, that she had lied to them and did so deliberately. And when asked why she would tell such lies, she said, because I hate him and I wanted to see him punished.